Good morning, everybody. I'm not going to talk about defamation of privacy and all that interesting stuff. I'm here to talk about something much more interesting, obviously, litigation funding and the changes to the rules that are coming in on the 1st of April, wearing my hat as a general commercial litigator. As John said, these are short and sharp talks. I will not pretend I can begin to cover all of the issues around litigation funding, so it's very much a quick skate through or overview of some of the key issues and some of the key changes that are coming in on the 1st of April. If anybody would like to talk to me about it, I would say after here, but unfortunately I have a rather key client meeting starting at 9 o'clock. Please give me a ring or drop me a line, and I'm very happy to answer any further questions, as would any of my other litigation partners, I'm sure. I'm slightly intimidated by the presence here of Michael Caine, the doyen of cost draftsmen, who I'm sure knows all of this much better than any of us could possibly hope to. Okay. Forget about all the statutory references, that's just there so you know where to find this if anyone's suffering from a particularly chronic degree of insomnia. The only key bit of information there is the 1st of April. That is when the changes come into force. What do I point this at? I wonder there. Right, what's out? Two big things are out. One is the other side picking up your lawyer's CFA success fee. Okay, sometimes there's a bit of misunderstanding out there, which is that CFA success fees are being banned or outlawed. No, they're all still there. The change is that the losing party no longer has to pay the winning party's success fee. But it's not retrospective, so if you enter into a CFA before the 1st of April, it doesn't matter how long the case lasts or when the costs come to be assessed, you will still operate under the old rules. Otherwise, in other words, the other side, obviously the other side being the losing side, the other side will pay your lawyer's success fee. So, you know, there are 3 or 4 weeks to go, so hurry now while CFAs last. The other sort of similar provision is, nor does the other side, the losing side, have to pay your ATE insurance premium. As some of you may know, the insurers have until now, typically over the last few years anyway, been offering deferred and contingent insurance agreements, which basically means the premium's not payable unless A, you win, and it's not payable until the end of the case. And the joy of the system has been that the losing party pays. If you lose, there's no premium to pay. So it's your classic win-win. Anyway, Lord Justice Jackson has spoilt that bit of fun for the insurance market, and so the other side will no longer pay the winner's insurance premium. Again, doesn't mean an end to AT insurance premium. You will just, as a winning party, have to pay it. And I guess economically, the effect of that is it's going to come out of damages. A couple of exceptions. Insolvency-related proceedings aren't subject to these provisions yet. And nor are privacy and publication proceedings, i.e. media litigation, essentially suing the newspapers and others for defamation, privacy and so forth. What's in? The big news, contingency fees, damages-based agreements, as Lord Justice Jackson has termed them, slightly oddly, but anyway, it's passed into the language now, DBAs we all call them. So what do they look like? They don't look anything like we thought they would look like. We thought, I think many practitioners thought, that one would be able to have partial, hybrid or discounted DBAs. In other words, you would apply the DBA or the contingency fee element to a portion of the solicitor's fees, rather like we operate CFAs here. But no, that is not going to happen. It's got to be all or nothing. In other words, the party pays nothing for the life of the litigation. The solicitors are required to fund their own costs and indeed the costs of counsel from their own working capital, which obviously could create issues when you're talking about a big and or lengthy case. Under the agreement, you can agree as a lawyer with your client that your fee is up to 50% of the damages recovered or possibly awarded. It's not clear. but the general view is it means recovered. It's just in the definitions term of the relevant statutory instrument, it does refer to the word awarded, which covers the solicitor's fees and counsel's fees, but not expenses such as experts, translators, and so forth. So what happens at the end of a case under a DBA? The successful party pays its lawyers the agreed percentage of damages, whatever that is. They have no more liability for their solicitor's fees or counsel's fees, plus any expenses, i.e. disbursements, as we would term them. And in the usual way, it can recover its legal costs from the losing party, but obviously those go straight to the party, so in effect they're netted off against the fee paid to the lawyers. But, and this is the but, is the very last bullet point, which is probably only relevant to sort of smaller cases or lower quantum cases, the amount you recover to the other side is limited, cannot be greater than the payment that the lawyers are getting under the DBA. So in other words, if you agree 50%, you recover £1 million, the lawyers are therefore getting 500,000, and the legal costs are 600,000, you're only going to be able to recover 500,000 from the other side. Is that right, Paul?
That's right.
Thank you. So what does the future look like? Well, there's obviously an element of uncertainty about it, but this is what we think. And certainly where we at Addleshaw Goddard will be coming from on this. CFAs remain very much centre stage. We don't see, for some of the reasons I've briefly alluded to, DBAs playing a big part in commercial litigation. It will be the Addleshaw Goddard no-win, low-fee model, i.e. discount on standard rates during the life of the litigation. If the case doesn't succeed, success to be defined, that's all you pay. If success is achieved, then you're liable to pay your lawyers an uplift to the standard rate, i.e. the difference between the discounted rate you've been fortunate enough to pay during the litigation and what you would ordinarily have paid under the standard rates, plus a success fee. And the success fee will be calculated as a percentage of the fees at risk, i.e. again that difference between the discounted rate and the standard rate, and it could be up to 100%. So take a very simple example. Your friendly AG litigation department gives you a discount of 30% on the standard fees. In the event of success, you're liable to pay the balance of that 30% and then a 30% fee on success fee on top of that. The uplift to the standard rates, well, all your costs up to the standard rates are still recoverable from the other side in the ordinary way. The only bit that isn't is the little bit of icing and marzipan on top, the success fee. But guess what? You've won the case, you've got the damages, so economically, I guess, that success fee is going to be paid out of the damages. So economically, perhaps it's a DBA light by another name. ATE insurance, the market's still going to be out there, we think. Are the premiums still going to remain deferred and contingent, i.e. deferred to the end of the case and only payable in the event of success? Who knows, but we'll have to wait and see. Some brokers think they are, others aren't quite so sure. Again, you will be liable for the ATE premium, but again, if you've won the case, in effect, economically, that's going to come out of the damages. And probably because of these changes, we're going to see more convergence between third-party funders and insurers. Third-party funding isn't affected at all by these changes, so that carries on. Certainly over recent years, although we haven't done a huge number of cases involving litigation funding here, it's certainly bigger in the market, increasingly available, and more importantly, the funders are coming up with more competitive and innovative models. The old sort of standard US style, we the funder take 3 times our investment or a third of the damages, whichever is greater, is obviously not always a very attractive proposition, and so they are coming up now with much more competitive models, basically taking a smaller return on their investment, sometimes stage, sometimes linked to the life of the litigation. Some funders are even looking at it as a sort of, or just a different asset class of investment, and provided they get a percentage return of X, a coupon if you will, per 6 months or per 12 months, that's all they're asking for. And as I've alluded to, it's quite hard to see the kind of case where DVAs, as they've been framed, are likely to work. It's got to be a big case, but it's got to be a very easy case, so the legal costs aren't too high. But if it's a case like that, then as a business, why would you give away your damages to, or up to 50% of the damages to your lawyers? So it's probably only going to be relevant where there's a cash flow issue or some other reason why you want to take the cost off the balance sheet. It's obviously got to have good prospects on the merits, always a good plan, but also on quantum, because it's damages recovered. And because it's recovered, there can't be any recovery or enforcement issues. So if it's a foreign defendant or a slightly iffy business that you're suing, it may not work. That's all I have to say this morning. Thank you very much.